The goal of the Civil Rights Act cannot be achieved
Punitive
unless
damages may be imposed.
special concerns arise from regulations that suppress commercial speech.
The thing may be within the letter of the law, and yet not be within its spirit.
Power between the states and the federal government will reduce the risk of tyranny and abuse.
Welcome to the legal environment of business, making decisions, managing risks. I'm Jane Maller. This course is not about how to practice law on yourselves or other people. In fact, if you have a specific legal question, you should consult a qualified lawyer in your state. Instead, I hope this course will show you a new way of looking at the world. Imagine the law as a window in a house, showing you one way of understanding and interpreting the actions of people. We'll see how businesses can make the kinds of decisions that allow them to accomplish their goals without risking misunderstandings or encountering legal problems in their dealings with others, and without violating laws or other people's rights. When the people at University Access came to me and asked me if I'd be interested in making a video course, I said, yes, I'd be interested. Did we have a contract at that point? If I'd simply said yes, or I'll think about it, would we have had a contract then? Like almost everything else in the legal system, that depends. And today we're going to be looking at contract law. What makes a valid contract and what doesn't?
You will get this in writing tomorrow morning.
We'll witness contract formation up close and through the eyes of a first-time homebuyer.
You've got a day to think it over.
We'll eavesdrop as she anxiously awaits the result of her dream home's inspection. And we'll explore the ups and downs of contracts.
We've got a band tonight. We've got a real problem.
As we go for a night on the town and a little salsa. Contracts are the lifeblood of any business because everything a business buys or sells, everything it needs to make a profit, involves contracts. A contract is a legally enforceable promise or set of promises, but not every promise becomes a contract, and not every promise is legally binding and enforceable in a court of law. So, to understand this legal transaction known as contract, we'll explore the significance of contracts by looking at some of the ways in which businesses use and rely on them. Then we'll consider the two major bodies of law that control contracts, the common law and the Uniform Commercial Code, known as the UCC for short. To see how a valid enforceable contract comes into being, we'll examine the process of contracting through offer and acceptance. Finally, we'll see that even if the parties have a clear agreement reached through offer and acceptance, the law generally requires more to create a valid binding contract. Each party to a contract must give something of legal value to the other party. This concept is called consideration. Now, every business wants to know that its contracts are going to work for planning and for managing risk. Because business depends on contracts, it's important to know what contracts are, how they're created, and what basic building blocks they need to be valid. Let's begin by discussing the significance of contracts. Contracts have been around since ancient times. Every society needs something like a contract, a mechanism that allows for promises to be enforced. Promises are statements of something that we're committing to do in the future. By creating binding, enforceable promises, contracts allow businesses to plan for the future. No one can know the future perfectly, but if we're going to enter a business activity with another party, we can try to think about what things might change in the future, what things might go wrong to provoke some sort of challenge to the transaction. We can provide for those risks and consequences in a contract.
Under the tub, it's leaking a little bit. You already know the diverter.
Real estate transactions are among the most common of all contractual arrangements. Looking at the ins and outs of a home purchase provides a good example of how two sides to a deal negotiate and minimize risks.
But you will get this in writing because that's how we're supposed to do it. And you'll have it tomorrow morning.
Okay, fine. Thank you.
After raising his kids and having 3 grandchildren, retired college administrator Bob McClure is ready for a change.
My motivation for selling the house is that I am 69 years old. My wife retired this year, and we're getting ready to move on and make things a little easier for ourselves so we could do some traveling or whatever we choose to do.
My other couple of concerns were like any real obvious earthquake damage or anything.
Office manager Stephanie Hammett is about to purchase her first home. She's been wondering if the McClure's house may be the one.
I don't see any shifting or anything.
I've been thinking about it for a few years, wondering if I could ever do it on my own without being married to somebody with 2 incomes, etc. I've always wanted a house to live in, not a place to rent or not an apartment.
It was only a few days ago that this was all set in motion.
I drove by Mr. McClure's house and I really liked it. I wanted to make an offer, in a couple of minutes, but I played it a little bit cool.
As with all contracts, Stephanie and Bob's began when Stephanie made an initial offer.
The initial offer was brought forth, and it was, in my opinion, too low. So what I did was offer what I felt was fair.
We got his counteroffer via fax. We looked it over, and I agreed to his terms and signed it.
I'll make the mad dash over to his house.
Bob had received more than one offer on the house, so he couldn't afford to wait very long for Stephanie's reply. He decided to put a time limit on his offer. If Stephanie failed to reply by the specified time, his offer was off the table.
That's it?
I gave it to my agent. She drove over to the seller's house because time was of the essence, and I was anxious to see what was going to happen.
The buyer's agent came to the house here with all of the papers, contracts, etc., that are necessary to consummate the sale. And my wife and I reviewed them and signed them.
They agreed on main issues such as the purchase price and move-in date, but like any good contract, Stephanie and Bob's agreement had to anticipate potential problems.
What came up is that the water heater, like a lot of them of that
For example, how could Bob protect himself if Stephanie decides at the last minute that she no longer wants the house after all?
When we entered into escrow, I had to give him a check for a certain percentage of the sales price.
But what it also tells the seller is that if she willfully chooses not to go ahead with the transaction, he knows that there's some money there in case he has damages.
Understandably, Stephanie's concern is in purchasing a home with hidden defects. Like most real estate contracts, this one provides for an inspection.
I was concerned that the house, when I take possession of it, would be free of any major defects, like a roof falling down or termites.
Today is inspection day, and both Stephanie and Bob know that there are consequences to the agreement they signed.
It's a little nerve-wracking because on the outside the house looks great. Even inside the house looks like they've kept it up really well, and it's really nicely kept, and they really like the house. But you never know what goes on, behind the walls or up in the attic or downstairs. He's been here about 45 minutes, checking the inside, up in the attic, all around, everything.
The contract requires that Bob deliver the house with no major defects. If Jeff, the inspector, finds major defects, Bob must fix them, or the contract gives Stephanie the right to walk away from the deal.
I happen to really like the owner a lot, and I don't want to cause any animosity between us because I want the sale to go through smoothly.
It is a nervous time because with the age of this house and the things that can happen to houses that are not in my control have to be dealt with.
Stephanie's agent knows that even the smoothest of negotiations can unexpectedly hit a snag.
I sold a home that looked perfect. The inspector went through the house. It was gorgeous. And he came back and he said, we only have 3 things that are wrong with the house. The roof has to be replaced. The chimney has come away from the house, and there are major problems with the pool and foundation. And the seller was unable and actually unwilling to do any repairs, was very indignant about it. And so we ended up that the buyer walked away from the property.
I'm going to look at the plumbing, make sure the plumbing...
So both buyer and seller know that the deal now hinges on the inspection.
pier posts, if any kind of shifting.
One essential structural feature seems to have everyone's attention.
I'm going to be looking for any kind of damage, the way the roof was put on, if it was put on properly, if the flashing's intact.
The make it or break it kind of things are if there's any major damage to the roof or if the roof has to be replaced.
I am aware that the roof is not leaking.
There's a slight leak at the air conditioning unit, the swamp cooler. Sellers, yeah, they get a little defensive. Normally it's not anything very major. You know, sometimes there is.
I would have to accept the things that were found, or I could say this is an unexpected thing and I'm not able to comply with this momentous thing, you know. Surprises can happen.
I've already lost sleep because this is a big deal for me. So I kind of am afraid of going home tonight, not getting much sleep again. But we'll see.
Now, the moment everyone has been waiting for.
I'm all done with the inspection. I don't see any extensive damage anywhere.
Right. Good. Right. Anything else that's...
The only other thing would be the plumbing connections at the water heater. It's in good shape.
Good.
It's a nice
I'm
home.
glad. That's a relief.
That's good news.
The inspection found no major defects, which means the deal will be completed with final paperwork in the next few days.
Okay, fine. Thank you.
It's just 3 weeks later. The deal is complete and Hammett is all moved in. This contract, which began with a simple offer and acceptance, now ends with the start of a whole new life.
I feel great. It's what I want. It's everything I wanted, and I'm really, really happy. I just wish I had more time, off of work to devote to the house. I would stay home every day. I mean, for now, that is. Let's go.
Contracts also allow businesses to plan for and exert some control over their future rights and obligations. They allow businesses to allocate risks. Now, in defining a contract as a promise or set of promises that the law will enforce, there's a hidden premise. The hidden premise of this definition is that not all promises are enforceable. If all promises were enforceable, I could teach you contract law in one sentence. But the law is fairly selective about which promises it will enforce and how they'll be enforced. And that's what contract law is all about. We should also take a minute to consider the values underlying contract law. Historically, one of these values has been freedom of contract. That's the idea that individuals should have the autonomy, the freedom, to choose the subject of a contract and the terms of a contract. But that freedom also carries responsibility. If you enter into a contract on certain terms, you're responsible for living up to those terms, even if it turns out later not to be such a great deal for you. Also, this freedom of contract is not an unfettered freedom. Increasingly, throughout the 20th century, courts placed various limits on freedom of contract, such as consumer safety laws and child labor laws. But even with these limitations, there's still a large area in which individuals can legally contract. Another important value underlying contract law is security of the bargain. By security of the bargain, I mean the reliable enforcement of contracts. For security of the bargain, legal rules and standards need to be clear enough that people entering into contracts can be relatively confident that courts will back them up if the other party fails to perform. Another value that's become increasingly important over the years is fairness, especially to weaker parties. Courts are more and more aware of the potential disparity in experience, sophistication, and bargaining power between different kinds of people, say, between large businesses and consumers. So you'll see different parts of modern contract law where courts have standards attempting to ensure that a contract is fairly entered into and fairly enforced. Before entering into a contract or resolving contract problems, it's important to know which rules apply in different bodies of contract law. One of these bodies of contract law is the common law of contracts, which has developed over time, case by case, through the decisions of judges. The American common law of contracts has been developing gradually over our nation's history. Keep in mind, since there are 50 different states, 50 different lawmaking jurisdictions, this common law of contracts is not uniform. There's nothing that requires the law of every state to be the same or to follow another state's laws. By about the late 1940s, when markets became larger and larger and businesses began doing multi-state, sometimes even multinational business, these widely varying contract laws became a concern. There was a move to create commercial laws that would be uniform for the most part among all the states. So, beginning in the early 1950s, a uniform set of commercial laws was proposed and began to be adopted by state legislatures. Finally, between the late 1950s and the 1970s, the Uniform Commercial Code, often called the UCC, was adopted by legislatures of all states.
What is the UCC? Is that a college? I don't know.
UCC.
United Chamber of Commerce.
United Council of Communists.
United Court something?
United Courts Coverage.
I don't know what the UCC is. Something courts probably, but I don't know what it is.
U.S. Circuit Court. I have no idea.
What is a UCC? Yuck.
The Uniform Commercial Code covers all phases of a commercial transaction, such as sales of goods, business leases of goods, and banking and financial instruments. There are some exceptions from state to state. Some states have chosen to customize the UCC to meet their own needs, and at least one state, Louisiana, hasn't adopted all of it. But generally speaking, the UCC is basically the same in every state. We'll be focusing on Article 2, which deals with contracts for the sale of goods. So we have, in essence, in contract law today, two bodies of rules. The common law of contracts, which has evolved from judges' decisions over time, and the Uniform Commercial Code, which is a more modern statutory set of rules. To understand the relationship of the common law and the UCC, imagine the common law flowing like a stream into the future, case by case, and the Uniform Commercial Code flowing out of that stream. The Uniform Commercial Code shares a number of ideas with the common law. At the same time, it's definitely taking a different direction. So, how do you know whether to follow the UCC or the common law rules in a particular contract? Basically, Article 2 of the UCC covers any contract for the sale of goods, things that are tangible, that can be touched and moved. The clothing that you're wearing is goods. It's both tangible and movable. Automobiles and textbooks are goods. So are hot dogs and candy bars. A building is not goods. It's tangible, but it's not movable unless, of course, it's a mobile home that's not attached to the ground. What about an employment contract? That's not a contract for something that's tangible and movable. It's a contract for services not covered by Article 2 of the UCC. So Article 2 of the UCC covers only that slice of the world of contracts that deal with contracts for the sale of goods. In the world of contracts not involving goods, the common law of contracts applies. It covers contracts for services, like employment contracts, contracts for real estate, which would include land and buildings, and contracts for intangibles, things that have no physical existence. A copyright or a patent or a share of a corporation are intangibles. There are many important differences between the rules and standards of the common law of contracts and the rules and standards in Article 2 of the UCC. A number of the rules about formation of contracts are different, as are many of the rules about performance of a contract, remedies for breach of contract, and even the time frame in which a person has the right to bring a lawsuit. In this lesson, we're going to be focusing on the common law. Let's look at the heart of contract law, the agreement. If you were to close your eyes and envision a contract, what would come to mind? How many people are involved? Where are they? What are they doing? What are they saying to each other? What does the contract look like? Now, if you're like most people, what you envisioned was 2 or more people, often in a room, maybe in some place like a lawyer's office around a conference table. You might have imagined them bargaining or negotiating back and forth, drafting up terms in a written agreement, and perhaps ultimately they were shaking hands and signing the agreement. That's what most people envision a contract to be. In fact, today, almost all the contracts we enter into don't look like that and don't happen like that. While there's got to be an agreement between the parties, there are many different ways to create an agreement. For example, more and more contracts are standardized transactions in which a party with greater bargaining power drafts up and simply presents the proposed contract to the other. And today, in such a formed contract, it's unlikely that the terms are going to be fully negotiated. You may be able to negotiate some terms, like price, but it's unlikely you're going to be able to negotiate all the terms of the contract. Another increasingly familiar example of formed contracts happen online. When signing on to an online service or downloading software, the terms "I agree" are often presented repeatedly, securing your commitment to the terms mentioned on the screen. Also, not all contracts are in writing. Many people come to the study of law with the preconceived notion that if you don't have something in writing, you don't have a contract. That's not necessarily the case. In our society, in many situations, contracts may also be oral.
How are you doing, sweetie? Good to see you. How's everything? Where you been?
Farouk Singh's optimism is what led him, after years of managing other people's nightclubs, to believe he could succeed in opening one of his own. But just 2 weeks after purchasing St. Mark's Tantra Bar, something happened that tested his positive outlook.
4 o'clock in the morning, we got a call saying there's 5 fire trucks outside your club. It's gutted. We came up here, all the doors were blown open. There was fire trucks all over the place. There's 6 inches of water on the floor. All our $100,000 worth of music equipment was destroyed. $70,000 worth of computers were gone. Everything was destroyed.
Fortunately, Farouk had insured the business, and despite being shaken, he refused to let the disaster dampen his enthusiasm.
My wife and I walked into this place and said, what do? We just bought this place. And we decided to wing it. It was a Saturday morning. We called the crew up at 5 o'clock in the morning, called everybody, all the friends we knew. We put the place back together and did 150 dinners that night with candles. 1 computer and candles.
Now, years after having pulled St. Mark's from the ashes, Farouk is not about to jeopardize his business, particularly when it comes to making contracts.
Hi! Are there lots of people here? Are there lots of men?
Contracting can be relatively informal in the music world. While oral contracts can be legally enforceable, when it comes to relying on them, Farouk is cautious. Since it may be more difficult to prove an oral contract than a written one, he tries to limit oral agreements to bands he has a long-standing relationship with.
You just don't hire a band. You see the band's reputation, you see what their draw is, etc. So you know the band has integrity. How many people have we done so far?
About 100.
Okay, and any comps?
Nope.
Good. Most of the bands know if they cross us once, even if we called up the other clubs, nobody touched them ever again.
Another frequent contract for a club owner like Singh is a large party booking. This type of agreement is generally oral. Singh remembers one such booking which involved preparing dinners for a 300-person party, only to have the host cancel at the last minute.
And his wife fell ill. He had to cancel his party, and his guests were all arriving.
To prevent disaster in a situation like this, Singh protects himself by requiring a non-refundable deposit.
Normally the party needs to be paid off a week before the actual date. So you're totally financially covered before it can happen.
Now we kind of shake it a little bit.
When he's not teaching salsa, Albert Torres manages bands that regularly perform at clubs like St. Mark's.
Let's try it without.
Occasionally, Torres relies on oral agreements in booking his bands. Recently, however, he ran into a bit of a problem.
I have a verbal agreement with a location that we've done business with before. Something internally is going on where they've changed who the person is that does the booking or whatever may be the case, but they gave us a date. We show up at the location on the given date, and they have another band performing.
We've got a band tonight. No, you're talking.
And we say, wait a minute, we have a verbal contract, as we always have had. They said, no, we had this other band.
We didn't talk about.
With the band all dressed up and no place to play, Torres was in a bind.
What happens is that I'm responsible, if I book a gig with the band, is that the band, when they show up, at that point in time, I'm responsible for paying them.
We've got a problem.
Since they had no written contract, Torres drew on his own notes to try to refresh the club owner's memory.
I detail all of my conversations. I really write it down and make sure. And I told him the exact date, the time that we spoke, and he was surprised that I had all of that documented. I'm going to be incorporating more of the written contracts.
Does that mean we have to put it in writing from now on? You know what happened? We had a change of management. And but I spoke with you. I understand.
What I've learned about contracts is basically that you should have a written one. Yeah, the chances are a lot better that you're going to get paid.
However Torres chooses to contract, there's one business he plans to continue working with for many years to come.
When it comes to this location, I have no problems whatsoever. We've been here almost 4 years, and they're every single Tuesday, rain or shine, and we haven't had one problem. When it comes to Farouk, I have a complete confidence, as much confidence as I can have, even being a street kid from New York City.
Let's try some music.
Although the law requires written contracts in some situations, in most cases, written contracts are not necessary, so long as the elements of a contract can be proved. Oral contracts are obviously harder to prove than written contracts, but other kinds of evidence can be used to prove that an oral contract existed. For example, there might be witnesses to the contract, or there might be a paper trail, like a series of letters that would establish the existence of a contract. Or there might be performances or actions that would bolster the idea that there's a contract. If it comes down to the question of one person's word against another, the chances of proving the contract might not be so great, and if so, that's something to consider in deciding whether it's worth the cost and aggravation of litigation. Lawyers in courts typically divide the parties' agreement in two parts, offer and acceptance. The offer is the proposal made by one of the parties about the terms on which that person would be willing to make a contract. Acceptance is the other person's consent to that proposal. Dividing the agreement into two parts like this can help to analyze whether the contract was really formed. So, let's look at what it takes to make a binding agreement. The first thing that's necessary for a valid agreement, whether we're talking about offer or acceptance, is intent. By intent, we're talking about the party's seriousness and readiness to enter into a contract. Courts want to assure that a contract isn't formed in a situation where the parties are still negotiating, or in a situation where the parties are not serious or still equivocating about whether they want to do something. So, to make a valid offer, there must be facts and circumstances that indicate that one party intends to make an offer. That is, they're prepared to go, they're ready to enter the contract as soon as the other party accepts the terms. And to accept an offer, there must also be facts and circumstances to show that the person receiving the offer is serious, that they're ready to enter into a contract, and they're not holding back or equivocating in any way. Now, a serious question in contract law is, what does intent mean?
That means that we are not going to look subjectively as to what this particular person thought he or she was offering or accepting. We are rather going to look at what an objective, reasonable person would have thought the parties were entering into.
Contracts are different from agreements. For instance, if I agree with someone that we'll meet in front of a movie theater at a certain time to see a movie, neither of us really expects that we'll be dragged into court and sue each other if that doesn't happen. What's missing is an objective intent to be bound legally.
What matters in contract law is not what somebody thought, but what signals they gave to the outside world. The words they used, the context, the behavior, actions like signing their name or shaking hands. All of this can show the seriousness of their intent. This focus on objective intent is important. If people were able to get out of an inconvenient contract anytime they wanted just by saying, "Oh, I was never serious," then no one could ever count on contracts. So to make sure that the transaction is secure, courts look to the parties' objective expressions of intent in both the offer and the acceptance. Now, one problem with this intent arises when the parties deal with each other orally, but they expect that their contract will be put in writing sometime in the future. When someone receives an offer, what that person says and does in response to the offer makes a big difference. If a person says, "Oh, I'll have my lawyer look at it and I'll get back to you," then plainly the person has not shown the intent to form any kind of a contract now. Rather, that person's reserving intent by putting off the decision till later, after an attorney has reviewed the contract and given advice. So, until the lawyer approves and the people sign the contract, there's no deal. But what about if the offer is made and the person receiving it says, "This is a great deal, I accept"? Maybe the parties shake hands and the person receiving the offer says, "Let me take this and have my lawyer draft up a written contract." Do the parties have a contract now? Well, there probably would be enough objective evidence that the offer was accepted and a contract made. The person receiving the offer has demonstrated a present intent to contract, and the parties anticipate that the future writing is going to record what they've already agreed. So the contract is now enforceable. But even with the showing of intent, there's a second requirement for a valid agreement. The parties' terms must be reasonably definite. This means that the offer must be specific because if it's accepted, a contract's created. And later, if someone claims breach of contract, a court would need to know what the parties were obligated to do, so it could tell whether the contract had been performed or not. Under the common law, a valid contract doesn't exist if the person receiving the offer doesn't agree on the terms. And how might that be shown? Historically, the common law of contracts has applied a standard for agreement on terms known as the mirror image rule. Under the mirror image rule, every term in the acceptance has to match every term in the offer. They need to be the mirror image of each other, similar to the idea of a spider on a mirror. Under common law, the person who receives an offer and has the power to accept it, who's technically called the offeree, is not free to add new terms or take away terms proposed by the person making the offer, who's called the offeror. If the person receiving an offer tries to change the terms, they're still negotiating and not forming an agreement. So if I offer you a job at $100,000 a year, and you say to me, "I'll take it at $110,000 a year," you're not agreeing to my terms. You're still negotiating. You can do that, but if you add or take away terms from my offer, we don't have a binding agreement. To create a contract, the offeree must give an acceptance on all the offeror's terms without any changes. But what about where you say something like, "I accept, but I've never been so ripped off in my life," or "I accept, but these terms are terrible"? Courts actually have a name for that, grumbling acceptance. And it's been held to be a valid acceptance as long as the person shows intent to enter the contract, despite the fact that they may be somewhat disgruntled about doing so. Another requirement for a valid agreement is communication. A person's uncommunicated desire to make an offer or uncommunicated desire to accept an offer is not good enough. That communication may be spoken, written, or expressed in an action, but some form of clear communication is necessary to create an enforceable contract. An offer can only be accepted if it's a live offer, one that's still open. There are a variety of factors that would cause an offer to terminate or be taken off the table. One of those is time. Frequently, people specify that their offers are only going to be open for so long.
You probably come across time limits on offers nearly every day. Maybe even the last time you sat down to lunch.
I'm waiting for 2 bowls of lentil.
Between the hours of 11 and 2 at Louise's Trattoria, a highly successful restaurant specializing in Italian and California cuisine, there's a very special offer on the table.
I'm Brent, and I'm the manager here at Louise's. It's a 15-minute lunch crunch is what we call it. And what it means is that we have a special menu, pastas and salad, pizzas and salad, and albacore tuna salad. But if you order off of that menu, once your order is placed, we have 15 minutes to get that to you. Otherwise, it's free.
An offer can only be accepted while it's still alive. And this one's only on the table between the hours of 11 a.m. and 2 p.m. Lunch crunch.
When's that 15-minute lunch special going to get here, man? We've been here 16 minutes now.
It's really tough to enforce. Difference in the clocks, you know, on my watch, their watch.
They don't mean 15 minutes in a row. That's the thing.
We're totally looking forward to it. Our business has increased probably about 25% since we've started the deal.
So once the offer is accepted, Louise's has 15 minutes to fulfill their end of the contract. Of course, offers like these keep the staff quite busy.
The thing that the servers have to do in order to get ready is, maybe take a shot of coffee or maybe down a Coke real fast to get that caffeine rush going.
Well, it's of scientific interest to me. I'm a culinary interest. I don't think it can do it. I mean, they say they can do it here at this restaurant, but I don't think they can pull it off in 15 minutes.
This is your California portobello pizza. You got your entree Louise salad, small Chinese chicken salad.
We're bringing our case to the people. We think it has to be a grassroots movement. We used to go to the top and complain to the management. We realize that any real social change has to come from the bottom up. Descartes taught us that. Can I talk a minute about the French Revolution?
So those customers who take advantage of the lunch crunch deal find that good things come to people who wait.
Here we are, folks. Great.
For 15 minutes.
That was pretty quick. 15 minutes, just like you said. Absolutely. Impressive.
Generally, even if the offeror does not specify a certain period of time, the offer will remain open only for a reasonable period, an amount of time which depends on the circumstances. Another way to terminate an offer is rejection, either through words or actions. For example, if an offer is made to you and you say, "No, I'm not interested," that's plainly a rejection. But counteroffers and conditional acceptances are also implied rejections. If I offer to buy your house for $200,000 and you say, "I'll take it if you make it $210,000, that counteroffer is essentially a rejection of my offer, and my offer would be off the table. Certainly negotiating is fine, but it's important to be aware that with a counteroffer, the original offer is terminated and there's no longer the right to go back and accept the original offer. That's an important point, and it's often misunderstood.
If you think about it, it's common sense, because we don't want to make everybody who makes an offer keep an inventory in their mind of all of the outstanding offers that are out there, so that when they get a counteroffer, they have to remember to go back and pull the plug to revoke the previous offers. Otherwise, we'd have too many offers floating around just waiting to be accepted, and they'd be, in many cases, highly contradictory.
A revocation also terminates an offer. The law says that the offeror is the master of an offer. So the general rule of common law is that in most situations, an offeror has the right to take back an offer at any time before it's accepted. This is called revocation of the offer. But there are some situations in which the offeror cannot take back the offer. Sometimes the offeror sells the right to revoke the offer, something called an option contract. An option contract is a separate contract in which the offeror promises to keep an offer open in exchange for something of value. In those situations, the offer can no longer be revoked. An example would be in real estate development, where a seller enters into an option contract to allow a buyer the time to determine whether they can obtain construction financing or whether they can build on the property and resell it at a profit. Another way of terminating an offer is through the death or insanity of the offeror. If the person making the offer dies or becomes insane before acceptance, then the offer automatically dies, goes off the table. Another thing that would terminate an offer is the destruction of the subject matter. Let's say I make an offer to buy your house, and in the middle of the night, before you've accepted, along comes a tornado and blows your house to smithereens. In that situation, the offer would be terminated. An offer can also be terminated if the proposed contract becomes illegal. Perhaps I make a contract to sell a quantity of tobacco products to an 18-year-old, and before acceptance, the state legislature passes a law making it a crime to sell tobacco products to anybody under the age of 20. In that situation, the offer would automatically be terminated. If a termination occurs in any of these ways, there's no offer to accept, which means that no contract can be formed on that offer. If a contract is formed, the time of formation could be significant. Generally, a contract comes into being at the point of the acceptance. However, this can be complicated because some contracts come into being by the exchange of promises, whereas others don't come into being until a party performs an action. This is an example of an agreement to purchase residential real estate. In the first provision, the offeror is saying, "I promise to pay you a certain sum of money to purchase this property." In the second, the offeree says, "I promise to sell you that property." This contract involves the exchange of promises, a promise for a promise. And so this is a bilateral contract. In a bilateral contract, a contract is formed at the point at which the promises are exchanged. In this case, the parties have exchanged promises as soon as they've both signed the agreement, even though no money has changed hands, and even though no one has handed over a deed or the key to the house or anything like that. It's important to understand when bilateral contracts are formed because some people think that until performance has started, they can back out of a contract without any consequences, and that's not necessarily true. In contrast, a unilateral contract is formed when one person's promise is exchanged for an act performed by the other. That is, one person makes a promise and the other person does something in return. For example, if I promise to pay you $100 to paint my office this weekend, how can you accept my offer? Simple. You perform the act that I'm requesting. A unilateral contract is formed when you have finished the act that I've requested, and that is painting my office. So, while many contracts are made through some form of instantaneous communication, such as over the phone or face-to-face, sometimes there's a time lag between the one person making the acceptance and the other person receiving the acceptance. The most notable example would be mail sent through the post office. If I mail my acceptance today and it doesn't get to you for 2 days, do we have an agreement while my acceptance is in transit? Do we have a contract at the moment I mail the acceptance? Or do we not have a contract until you receive the acceptance? In the offer, the person making the offer has the power to say that no acceptance is effective until it's received. But if the person who makes the offer fails to specify that acceptance will not be effective until it's received, then the law uses a different presumption. It's called the mailbox rule. The mailbox rule only applies in situations where the parties are dealing in a mode of communication in which there's a time lag between the dispatch of acceptance and the receipt of acceptance. If a person sends an acceptance by a mode of communication that was authorized, that is permitted, by the person who made the offer, then the law presumes that the acceptance is effective at the point that the offeree dispatches the acceptance. And this is called the mailbox rule. The person responding to an offer can use the method of communication suggested or used by the offeror, a method that's as fast or faster than what the offeror has specified, or a method that is commonly used in the offeror's trade or business. For example, Let's say that you get a mailing from your automobile insurance company telling you that your insurance is about to lapse. They're offering you the opportunity to renew your insurance, and with that mailing, they include an envelope addressed to their office for you to use in making your payment. So, in states that follow the mailbox rule, your renewal is effective when you put it in the mail, so long as it's properly stamped and addressed. But even a good offer and acceptance is not enough for the formation of a valid contract. The law wants contracts that have some economic significance. To accomplish that, U.S. contract law generally requires that to be enforceable, an agreement must be supported by consideration. This is not consideration in the sense that we usually use that word. It's not being kind or nice to other people. Consideration here means that something of legal value is given in exchange for a promise. In other words, there's a bargain for exchange between the parties. By contrast, gratuitous promises, the promises made out of the goodness of one's heart, where nothing is asked for in return, generally are not enforceable because nothing was bargained for in exchange. The general rule in contract law is that gratuitous promises are not enforceable. Another way to state this is that if you want to be able to enforce another person's promise, you must be able to prove that you gave consideration in exchange for the promise. The legal name for the person who makes the promise is promisor, and the legal name for the person who receives that promise is promisee. But for ease of explanation here, let's call the promisor the promise maker and the promisee the promise receiver. In determining whether consideration exists, it's helpful to divide consideration into separate elements. One of those elements is legal value. The person who receives the promise must give legal value to the person who makes it. Now, what's legal value? Legal value means something that the promise receiver has the right to give, but has no previous obligation to give. Legal value can take different forms. An act or a promise to do something a person has no previous obligation to do, or an act or a promise to refrain from doing something where the person has the right to do it.
When it comes to the concept of consideration, look no further than your friendly neighborhood restaurant.
Hi, welcome to Lisa's. Thanks. Would you like to sit inside or outside?
Inside. Yeah, inside.
Like many fine restaurants, Louisa's Trattoria periodically takes large party bookings for special occasions. Fred LeFranc is president and CEO of Louisa's. He recalls one such booking in particular.
There was a time that we did rely on our agreements in terms of a banquet. There was a wedding party that was booked for a couple of hundred people.
The proud parents of the bride-to-be had booked a 200-guest party at Louisa's for their daughter's upcoming wedding reception. This was an example of a bilateral contract, a promise for a promise. The first requirement of consideration, legal value, was fulfilled. The parents' legal value was their promise to pay for the 200 guests. They also promised to give Louisa's a deposit of 2/3 of the cost of the event and pay the last third the day of. Unless Louisa's received 48 hours notice of cancellation, the 2/3 deposit was non-refundable. The restaurant gave legal value by promising to hold space for that party and provide the food, beverage, and service on the agreed-on date. A second requirement for consideration is that the legal value given has to have been a bargain for exchange. Now, this doesn't mean that LeFranc and the parents actually must haggle or negotiate, but it does mean that the legal value must be what the other person was seeking. Here, the parents got what they wanted, the promise of a fully catered banquet. And Louisa's got what it wanted. The parents promised to pay for the banquet by the requested date. An important point to remember is that each party's legal value need not be of similar or equal value. Unfortunately, not every bride gets what she bargains for.
Turns out that the groom stood up the bride at the altar, and her sobbing mother called up to ask me if I would agree to cancel the wedding party, and I said I can't because I already had bought the food and had scheduled the labor because this happened the day of.
On consideration grounds, Louise's could enforce the parents' promise even though the wedding never happened. The parents' contract with Louise's was enforceable.
So they decided to have a party, and it turned out to be a fabulous party. The bride came in with all her side of the family and invited more friends and had a big celebration that she didn't have to marry that jerk.
Now, let's look at transactions that are not legally binding because they fail to meet the requirements of consideration. We can apply the first two elements of consideration to see why. The first transaction involves a promise to perform a pre-existing duty. That means a promise to do something that you already have the obligation to do. There are lots of ways in which people can have pre-existing obligations. Most frequently, a pre-existing duty is established by contract, but sometimes the pre-existing duty is established by the criminal law or by other kinds of public duties. A promise to perform a pre-existing duty is not consideration because it has no legal value. Another exchange that's not consideration is an illusory promise. Something that sounds a lot like a promise, but it's not because it doesn't bind the promise maker to do anything. For example, if I promise to pay someone $500 if I feel like it, that's an illusory promise because I'm not really promising to do anything. So a cancellation clause that gives the right to cancel at any time without giving notice or without having a good reason is also an illusory promise. Essentially it says, I'll pay if I feel like it. I'll stay in the contract if I feel like it. An illusory promise is not consideration because it has no legal value. On the other hand, courts have enforced contracts in which a person promises to use his best efforts in doing something. Why isn't best efforts an illusory promise, given that it's impossible to quantify? To answer that question, let's say, for example, that I'm an agent in the entertainment business, and I say that I'll use my best efforts to get you a starring role on television. In this case, we may not know exactly how much effort is required, but at least I've promised to do something and to do it in good faith. So this is consideration. In contrast, an exchange that might look like consideration but is not has the unfortunate name of past consideration. I say unfortunate because past consideration is not consideration at all. It's just a regrettable connection of words. Past consideration means an action performed before the other person's promise was made. And that past action can't be consideration for the other party's promise because it was not given in exchange for the other party's promise. For example, let's say that Max has retired from his job after 50 years of wonderful service. He's given his notice, he's had his last day on the job, and after that day, the boss throws a big retirement party for Max. At that retirement party, the boss makes an announcement. The company is going to pay Max $500 a month as a pension for the rest of his life, as a reward for his excellent service. Is the company legally obligated to do so? No. Why not? Because Max has already completed his service to the company. It's past consideration. The bargain for exchange is missing because Max gave all of his value before the boss made the promise of a pension. Now that you understand the general rule that consideration is required to enforce another person's promise, I want to talk about an important exception to that general rule. A situation where a promise not supported by consideration can still be enforceable. The doctrine is promissory estoppel, which enforces promises because of reliance and fairness rather than because of a bargain for exchange. And this reliance is not just expecting something to happen or counting on it, but rather taking action or refraining from acting because of faith reasonably placed in someone else's promise. If under all the circumstances it would be drastically unfair not to enforce the other person's promise, a court could use this doctrine of promissory estoppel to enforce the promise. In this lesson, we've studied the legal rules that determine whether and when parties have created a legally binding agreement known as a contract. We considered the significance of contracts in society and business, and we examined the values underlying contract law. Next, we considered the two basic bodies of contract law, the common law and the Uniform Commercial Code, commonly called the UCC, which establish different legal rules for different types of contracts. Then we examined the process of contracting through offer and acceptance, learning what's necessary to form a legally binding agreement. Finally, we talked about consideration, the legal value and bargain for exchange that is necessary for the formation of a valid, enforceable contract. I'm Jane Maller, wishing you good luck in making decisions and managing risks. I'll see you next time.
To learn more about the legal environment of business or other courses like this, visit PBS online at www.pbs.org/als/Quizzic.
This is PBS.